I make one request. But, 482 petition, my lord, special bench cases. I have moved before the vacation bench, my lord. But due to, my lord, it was not reached. 20th your, date has been given today, my lord. It was not listed.
Thursday.
Great.
Your Lordship, I have filed for the quantum of application, preliminary notification and final notification covered by judgment, Your Lordship. It will be taken up tomorrow.
We'll give it on the land acquisition date.
Your Lordship, the petition of land acquisition, Your Lordship, we are impleading respondents. After 40 years of acquiring, the original owners have come and told that the acquisition is wrong. The government had acquired it, Your Lordship. Can we have it any day in this week?
My lord, the writ petition of land acquisition, I was not even made a party. I am the concerned authority. An order status quo has been obtained. I've been subsequently impleaded. The construction of a state highway has been.
With your lordship, permission, Lord, may I just mention item number 53?
You have to just wait. It will be called page wise. Then you make a
I'll
mention.
wait, Lord. I'll wait. I'll of course.
This matter.
Yes.
Next week.
Adjournments list 1, page number 1 to 6, page number 2, serial number 7 to 13, page number 3, 14 to 18, page number 4, 19 to 22, page number 5, 23 to 29.
Lord, serial number 25.
Yes.
And withdrawing the petition.
Counsel for the petitioner filed a memo which reads as here under in light of the same petition is dismissed.
Page number 6, 30 to 36.
Lord, serial number 33.
30?
33, my lord. I
Yes.
correspond to 10.
Yes. Have you informed the other side? At request, relist the matter.
16.
Yes.
My lords, I'm for petition number 2 and 3 in item number 33, and I have no information about the adjournment. I have no information. My lord.
33.
Yes, my lord.
33.
Yes, my lord. And for petition number 2 and 3.
He's for the petitioner, my lord.
List 133.
Yes, my lord.
Let us see, he's seeking for some accommodation. We'll have it on some other day.
My lord, kindly hear the matter today.
16.
But I have
16.
no information. But my lord, I have no
16.
information of this motion.
16th. Yes.
16. Page number 7, 37 to 40, 41. Page number 9, 42.
Your Lordship, 42, Your Lordship.
Yes.
For respondent R2 and R3,
Yes.
the similar notification matters has been listed on 9 to Your Lordship. This matter also been listed on 9.
List on 9th of February. You must inform the petitioner.
Inform.
You have informed.
For petitioner,
Yes.
my lord, there is an interim order in that matter.
Interim order in operation extended till the next date.
Can it be post 9th any date, my lord?
So let us see on that day what's the connected matter, then we'll.
Watch out.
Page number 10, 43. Page number 15, 44 to 46.
46, please.
Yes.
1 week time of notice.
Harish VS.
Harish.
You're for the petitioner.
I am for the.
Okay.
At request, relist the matter. But there's somebody else in the connect 46.
46.
Relist the matter on.
3, 2. List 2, page number 1, 1 to 6, page number 2, 7 to 14, page number 3, 15 to 22, page number 4, 23 to 26.
26, Your Lordship.
26.
2 weeks time may be granted.
At request of the petitioner, relist after 2 weeks.
Page number 5, 27 to 32.
46, my lord.
Page number 6, 33 to 36.
35.
Yes.
And summons may be issued to the respondent number 3 and 4 in this matter. I will personally.
The steps to be taken for R3 and R4. Petitioner is at liberty to take out notice by way of hand summons. But you must inform the other side. Yes. Yes, next.
Page number 7, 37 to 39. Page number 8, 40 to 43. Page number 9, 44 to 48.
47, 46, my lord.
46.
46, my lord. Kindly tomorrow, my lord.
Lordship, we are filing the vacating stay, my lord. There is some urgency for review because 38D application has been filed. As per the statute only, if we are not, if we are rejected their application, in 6 months it has to be vacated, my lord. So.
Kindly tomorrow, my lord.
If it is tomorrow, I have no objection, my lord.
Let us see. They have short date.
My lord, ಸ್ವಲ್ಪ urgency ಇದೆ.
Let us see.
ಅವರು
ನಾಳೆ ಇವರೇನು ನಾಳೆ ಕೇಳ್ತಿದ್ದಾರೆ. ನಾಳೆ
29th, my lord.
my lord, ಅವರು
repeat.
my lord, deliberately they are taking
Repeat
time,
tomorrow.
my lord.
Repeat tomorrow.
Kumar. Page number 10, 49 and 50.
My lord, serial number 49 for the petitioner, my lord. Can you have it next week, my lord? Inform the other side, my lord.
49.
I'd
49.
I'd request list week after next.
Please.
Page number 11, 51 to 55, 51
My
to
lord,
53.
my lords, serial number 53, my lords, it's a final disposal matter.
Yes.
I appear for the respondents, my lords, we have informed both the petitioners.
Petitioner number 2 in the matter.
We have informed both the petitioners, my lords. Mr. Siddharth Luthra was appearing in this matter. If your lordship may have it kindly on February 11th, my lords.
My lords, 11th may be a slightly long date, my lords. Any date next week or week after, my lords. It's on a short point, my
Very
lords.
well, my lords. Any date in the first week of February, my lords.
9th.
My lords, may I request for any date shorter than that, my lords? Any date in the coming.
We have land acquisition only on Mondays.
My lords,
So
then
ask
may I request for 2nd, my lords, 2nd of February.
Second list is full.
Very well, my lords, then I'll leave it to
9th.
the convenience of the court.
9th.
Very well, very well. My lords, the interim order may kindly be continued. my lords.
Modern operations extended till the next day.
I'm grateful.
Matter, my lord, has to come on hearing on IM, my lord. Last time there was an order, my lord.
Which?
Because
Same matter.
we filed IA for vacating the interim order.
List IA for vacating, my lord.
List in the stage of
Hearing on
interlocutory application.
Please.
On 9th.
Very well, I'm grateful. my lord.
Serial number 1.
Your Lordship, sir, I request one matter, it's a covered matter, Your Lordship. but,
Give it.
uh,
Mentioning time is over. Should come sharply
Fresh
at
matter.
10:30. Give it. Next.
List 2, fresh matter, serial number 1. Savita.
These two now.
List 2, serial number 1. Savita.
Yes.
It's a GST matter. In this case, the petitioner ran a severe loss in his business due to COVID and he applied for cancellation of
Appeal is
GST.
appeal is dismissed on delay.
Your Honor.
Appeal is dismissed on ground of delay.
Yes, appeal is dismissed on ground of delay.
Yes, madam.
In this case, it was an ex parte order. This man, there was a deregistration order which was effective as of 31/3/2022, and there was this order passed on in the year 2025.
Just only.
My lord, there is two orders, my lord. We have issued the notice. They have not, despite issuing notice, they have not appeared. Even through RPT also we sent, they have not appeared. So hence passed the ex parte order. Afterwards, registration is cancelled. With regard to registration of cancellation is, restoration is concerned, I don't have any objection. It's covered by this honorable court decision that may be restored. And with regard to ex parte order is concerned, I deem it has to go before the show cause notice. At the stage of show cause notice, let them take the contention. But before taking the contention, registration means they have to pay the tax penalty interest. Then they can, liberty may be granted them to take the fresh contention with that.
It's a totally misleading matter, Your Honor. In this case, after deregistration, notice was served by uploading the notice, show cause notice on the portal, which this petitioner did not have access at all because his registration got cancelled as of 31/3/2022. And then in the year 2024, just for the heck of serving notice was uploaded on the portal. And after that, it was deemed like it was taken as of notice was served and order was passed. And the first respondent took the pain in sending the order by post. That is this is the Annexure A order which was sent by post to the petitioner's address, home
Just-
address.
Just one.
But
Now, this is not a case where they're seeking for revival. They are saying that it has to be cancelled with effect from that date. So now we'll have to look at the appellate order was appeal was dismissed only on the ground of some 14 days delay.
My
No,
lord,
no,
with
just-
regard to delay is concerned, statutory provisions, they
Correct,
cannot
correct.
condone the delay.
Correct, correct. So
Ex
if
parte
you-
order, it may be remanded, opportunity is not provided, it may be remanded. I'm not objecting with.
No, suppose we were to allow the appeal. Suppose we were to allow the appeal, then it would stand remitted to what stage?
No, I feel fit, my lord. It's a ex parte order. Let it go back at the stage of show cause notice. Let them take the contention because opportunity is not, they availed.
yes, first respond, already explanation was already given to the first respondent after the order was passed. Because the petitioner through his chartered accountant approached the first respondent saying that this registration was already cancelled and he was not informed. He was not given proper notice. So the first respondent informed the petitioner saying that, okay, just submit a
Correct.
rectification
So-
letter.
So now we'll set aside the adjudication also and remit it to the stage of reply to show cause.
Yes,
You take
yes.
that.
And restoration of GST is concerned, my lord. I'm not objecting with that also. After restoration, let them permit them to file the demand what is there in the.
20,000, 10% of the tax has already been paid. It's already
No, I'm
remitted.
not telling. Tax and penalty.
That is
Interest
not, that may not be considered now, Your Honor.
No, they have not sought for restoration of that. They're saying they want to close. So now we'll allow that order, remit it back to reply to show cause. Let it be decided then.
To send at the stage of show cause notice, I don't have objection because they didn't avail the opportunity to
Yes.
contest.
The
It's a fair.
petitioner has called in question the correctness of the order at annexure A dated 10/2/2025 passed by the Assistant Commissioner of Commercial Taxes. Petitioner in terms of annexure A, the authority has passed an order under section 73(9) subclause 9 of CGST/SGST Act 2017 and has raised a demand. Petitioners also challenged the order at annexure B, which is an order rejecting appeal on the ground that delay was filed belatedly. Petitioner sought for remitting of the case to the first respondent and for an opportunity to be heard before final orders are passed. Full stop. The brief facts are that the petitioner had sought for cancellation of his registration, GST registration with effect from 31/3/2022. Full stop. Is further submitted that the first respondent, however, on 10/2/2025 had issued the impugned adjudication order. Petitioner submits that they were not aware of notices issued as they had sought for cancellation of the registration and notices posted in the portal did not come to their notice, and accordingly they did not make out reply to the show cause notice, which eventually culminated in an order of adjudication. As against such order, appeal is filed, though belatedly, and said appeal was rejected only on the ground of delay. The Council for the Revenue submits notices have been issued as is permissible in law, and the lapse of the petitioner has resulted in passing of orders. Full stop. However, it is submitted that the court may pass appropriate orders, taking note that the order was passed without any reply of the petitioner. Full stop. So far
In
as
that, sorry, interference. We have issued the notice, my lord, in the
Correct.
portal, even email.
I've stated. Full stop. Peruse the order at Annexure B, which is a order of dismissal of appeal on the ground that the same was filed belatedly. Full stop. While noticing that the appellate authority has no power to condone
Yes, madam.
delay in the taking note of the delay in the present fact, it would be
As per
appropriate.
section 107,
It would be appropriate to take note of the order challenged in appeal. That is the order at Annexure A itself. Full stop. The reason for such an approach is in light of the order at Annexure A having been passed without any reply on behalf of the SSC, who is the petitioner herein. Full stop. Though various contentions have been urged, however, taking note that the adjudication order is passed on merits in the absence of any reply, it would meet the ends of justice by setting aside the order at Annexure A and remitting the matter back to the respondent number 1 to the stage of post show cause notice. Petitioner is at liberty.
at the stage of show cause notice to give the reply.
Correct, correct.
Yeah.
The petitioner is to make out reply to the show cause notice. We'll fix a date.
Yes, madam.
Uh,
If
pet-
they didn't appear in that date,
Petitioner to-
this order may automatically stand, madam.
Petitioner to approach,
That may not be given, Your
to
Honor.
appear. No, you appear.
We will appear, but the day we appear, the respondent one may not be in office. Then we may have to
Correct.
return.
That you
So
take
that
an,
automatic.
that you take a
order.
written acknowledgement. We'll see. Petitioner to mark appearance before the first respondent on
February.
2nd of February at 11:30 a.m. In the event petitioner does not avail of the opportunity and is not able to demonstrate bona fides, the indulgence granted by this court would stand revoked. All contentions on merits are kept open. Yes.
Serial number 2, Vamsi Krishna, Gopal V, Harish.
For the respondent number. My lords, appearing for the petitioner, kindly have it passed over, my lords. My senior is held up in the other court.
Copy is not served.
My lords, the copy is already served, my lords.
Sir, one more set, sir, one more.
It's not been served on me at least.
Pass over, you serve copies.
Yes, my lords. Much obliged.
Number 3, Prashant. Number 3.
Lordship, this matter arises whether the transaction value should be charged on the
Yes, who's
MRP,
there? Yes.
Demand but
on the MRP or on the transaction value, Your Lordship.
Yes, who appears for the respondents? GST Council. GST Council.
Central state. Central
Third one.
Union. No, Central state. Central Union of India. Girish sir,
I appear for respondent 1 and 2.
Girish sir, बताइए.
Annexure E, the
You
two
appear for-
notification already quashed by the board. So this writ petition is not maintainable at all.
Your Lordship, the coordinate bench has already quashed.
Use the mic, use the mic.
Your Lordship, the coordinate bench has already quashed those two annexure A and B, Your Lordship. It is at page number 44 of my.
That is
However,
now
this is
challenged.
subject to appeal. There is no order passed in the appeal, Your Lordship. It's not yet listed before the court, Your Lordship. Annexure E, Your Lordship, at page number 44.
Now, what is A and B?
Your Lordship, A and B are the two notification, Your Lordship, wherein a cess under the act, the cess came to be replaced by MRP, Your Lordship. Now I am forced to pay the cess on the MRP rather than the transaction value.
So when it is quashed, then why are you filing again?
Yes, madam. This
Your Lordship,
repetition
this
not
is
mental.
with respect to other petitioners, Your Lordship.
Why do
We
you?
ordered it at
No, it
those-
was only got to the petitioners, that's why, Your
It is
Lordship.
applicable to all.
Where is it?
No, Your Lordship, no, it's gone for appeal also, Your Lordship, that's why.
Appeal is filed by?
Appeal is filed by union, Your Lordship.
It's still pending, is it?
Yeah,
madam.
it's not yet come before the court, Your Lordship, still before register protocol.
Okay. So and so.
Yesterday, I had also given a case status, Your Lordship. In similar situated matter, the single bench has already stayed the impugned notification. This matter was supposed to be tagged along with that. Your Lordship.
Learned counsel Shri Timmanna but directed to accept notice for the
For that point number one.
Petitioner submits that the notification challenged in the present writ petition at annexure
A and B, Your Lordship.
A and B.
B, yes, Your Lordship.
The subject matter of challenge in WP 100239 of 2024 and has been set aside. In light of the same, no, if it's set aside, what stay you can give? How can we stay
Your
something?
Lordship, against
Madam,
this petitioner,
already
against this
granted,
petition, it was not stayed, Your Lordship. It was on,
Council notification when it is set aside,
yes, Your Lordship.
appeal is filed, no stay. What stay? Notification is not in existence. You take out notice. How are you prejudiced?
Your
Not-
Lordship,
Council notification is not in existence. It has been
Yes,
set
ma'am.
aside. That order has not been stayed. So what are you going to seek stay of?
Your Lordship, then may quash it in terms of that order, Your Lordship. Quash allow this petition in terms of that order, Your
How
Lordship.
can
No,
I?
madam. Same prayer is prayed to quash the same notifications already quashed.
You take out notice, I leave it at that. I don't know why you filed it. There was no necessity to file it. It's
Yes,
already a dead notification. How can
Yes,
I set
madam.
aside a dead notification? List week after next. In case something happens in the writ appeal, you move it. Yes, next.
4. Serial number 4, Ravi.
My lords, this is a GST matter, my lords, where an adjudication order is passed for multiple assessment years, my lords. Multiple show cause notices have been
Yes.
combined and dealt with.
Yes.
I believe Arvind Savana.
For which
I take notice, my lord.
Learned Councillor Arvind Chavan accepts notice for the respondents.
Page number 19.
Petitioner submits that the order at annexure A is passed with respect to multiple years.
Multiple years.
And in light of the order passed in WP,
My lord.
Perumar, my lord, the single judge.
so and so
15810 of 2024.
of
2024, my lords.
24.
Please.
The present writ petition also requires to be allowed. In light of the contention raised, there would be stay of
Next year, my lords.
annexure A. Yes.
So can have it week after next, my lord. I'll try
This
to
week
come.
after next.
5. Mohammed.
Motor vehicles.
Writ of mandamus.
Which one the same covered?
Yes, my lords. Coordinate bench of this honorable court has granted stay.
Copy, copy.
AGA, HCGP accepts notice for respondents 2 to 6. Central Government, Union
My
of
lord,
India.
before this honorable court, connected matter is
Correct, correct.
posted on 2-2.
Yes, yes. Union of India, Manjunath. B. Pramod is directed to accept notice for the first respondent. Petitioner has challenged the sought for a direction to the respondents to refrain from demanding tax in respect of the scheduled vehicles and has raised various contentions and submits that this court in an identical factual matrix on similar questions of law raised has stayed the demands made and refers to interim order passed in WP 35182 of 2025. In light of the same, the respondent authorities are restrained from seizing the vehicles.
Yes, but liberty may be given to the respondent
While
for
liberty is,
investigation.
while liberty is reserved to the respondents to inspect,
Inspect, investigate, inquire.
inspect and inquire, investigate and inspect the vehicles. List along with WP numbers, so and so on 2nd of February.
But
6, sir. Mahesh sir.
Petitioner suffered an ex parte order from the GST.
Yes.
After receiving show cause notice,
may be remanded back, my lord, at the stage of show cause notice. Very less demand also. No cost is required.
The petitioner has called in question.
But my contention may be taken, my lord. We have served the notice. They have
Yes,
not
my lord.
appeared.
Yes, my lord. I also admit, my lord, the notice is served.
Petitioners challenged the show cause notice at annexure A and B as well as the order in original at annexure D and E. It is the case of the petitioner that insofar as the case of the petitioner was taken up for scrutiny and show cause notice issued. However, due to bona fide lapse on part of the petitioner, there was no reply to the show cause notice, which eventually has culminated in order in original, raising a demand. Petitioner submits that taking note of the bona fide lapse of the petitioner, matter may be reopened and appropriate orders passed. Counsel for the respondent state submits that the notices have been issued and it is the lapse of the petitioner for not having availed of the opportunity. However, it is submitted that as the orders passed are ex parte, the court may pass appropriate orders. Taking note that the order at annexure B, annexure C,
annexure D and E,
annexure D and E are admittedly ex parte orders passed without any reply on part of the petitioner. It would be appropriate to remit the matter back to the stage of reply to the show cause notice, which would meet ends of justice. Full stop. It would also enable the authority to adjudicate on the merits of the matter. Full stop. Accepting the lapse on part of the petitioner to be bona fide. It would be appropriate to set aside the order at annexure D and E and remit the matter back to the respondent number two. To the stage of reply to show cause notice.
Yes.
Petitioner to make out reply to show cause notice at annexure A and B.
Yes.
Full stop. Petitioner to appear on 2nd of February at 11:30 a.m. Needless to state, in the event of petitioner not appearing before the authority, the indulgence granted by this court would stand withdrawn. All contentions are kept open. HCGP accepts notice for the respondent. Yes.
7. Ganapati, serial number 7.
ನೆನ್ನೆನೂ ಬಂದಿಲ್ಲ.
I served a copy, my lord. It is regarding common show cause notice, which your lordship passed in serial number 4.
Serial number
4, my lord. Common show cause notice.
the petitioner. No, but he should come. Yesterday
should
also
come.
he didn't
Pass
come.
over. Let him come.
Yesterday also he didn't come. Pass on.
8. Devendra, BR.
Lord, serial number 8, I'm appearing.
Yes.
This is a apartment owners association. The income from the members is not chargeable to income tax under the principle of mutuality. For assessment year 1819 and 1920, it filed the return of income, claiming the income from members as not chargeable to tax and filed the return of income. Inadvertently, this income not chargeable to tax was not filled up in the exempt income schedule. It was not filled up. So there was a apparently discrepancy between the income claimed as exempt and where it was not filled up in the exempt income schedule, because of which the CPC Bangalore had issued communications and the intimation under section 143 subsection 1. These communication and the intimation went to the email address of the accounts manager, who was not present when the intimations were received. Moreover, during COVID time in 2020, these intimations were passed. This was not at all noticed by the association, my lords. Totally, there was it completely missed the attention of the association. After some time, after a long period, when the outstanding demands were enforced against the appellant, the petitioner came across about these demands and the intimations passed. And all the time limits under the Income Tax Act has been exhausted, my lords. The time limit for rectification, all those things have been exhausted. So therefore, we have filed this writ petition for both these years. The only prayer is let it go back to the assessing officer for verification, my lords.
My lord, this is an appealable order, my lord. The assessee has approached this court after a lapse of 6 years, my lord. My lord, normally these intimations are sent. One is to their email ID, and the intimation is sent to the current mobile number as a live alert. And even they would have uploaded it in the e-portal, my lord. The assessee cannot contend that just because the email was sent to one of his employees' email ID, he did not know, my lord. It's not a reasonable cause where this honorable court warrants interference. They can challenge in appeal, my lord. Intimations are always appealable orders.
Lords, from para 21 onwards, I have explained the reasons for the delay in approaching the Honorable High Court, my lords.
Correct. Because of this delay, you rather go in appeal only.
Lords, after 6 years, there will be definitely the delay will not be condoned by the C8 appeals, my lords. And the time limit for rectification is 4 years, which has already elapsed, my lords. And the association was caught with lot of legal disputes also, which I have explained in para 21. In summary of events, I have explained it completely, my lords.
My lord,
because the committee is going to change year after year.
My lord, it so happens.
I repeat, your headaches are your headaches. It's not the headache of the department.
My lord, if in the written, if they had properly filled up the right column, my lord, the CPC would have properly adjudicated it and it would have generated the intimation, my lord. Just because there was a wrong entry, my lord, automatically CPC is a mechanized process. It sees the entry If it is, if they have put it in a separate entry, they have generated the demand, my lord. That's all.
Lords, the income which is not,
So you suggest now what is to be done?
Lords,
It's
my only prayer
applicable
is,
Your Lordship, let them file appeal, my lord, with continuation of delay
Now, the only
application.
problem is that, my lord, the CPC cannot once again re-agitate or re-look into the matter. Maybe the jurisdiction assessing officer may have to look into it, my lord. That is the worry that.
Your Lordship, the computer cannot redo it, my lord. 143 one is computer generated one. It cannot be remitted back to the CPC, my lord, Central Processing Office, my lord. Now, your Lordship can direct the assessee to approach the first appellate authority, my lord, by filing an appeal. Your Lordship can also that first appellate authority can take a lenient view considering the reasons shown by the petitioner, my lord.
my lords, in this case, the income is completely not chargeable to tax on
So
account of mutuality, my lords.
we'll make an observation to that effect, appellate authority to look into that. And now whether they have the power to condone.
Yeah, it can be condoned, my lord. If sufficient, there is no time frame, fixed time frame, like in GST. my lord.
GST, there is 60 days plus 30 days, my lord, 90 days. In income tax, there is no time frame for CIT appeals.
Only thing is he has to pay some deposit, is it?
No, my lord. That is also if they seek for stay.
They can also seek a stay,
Department is
my lord.
already behind the association for the payment of these demands, my lords. They have already sent the notices for payment of these demands. Only after that we
6
came
years
across,
they
my
were-
lords. My lords,
Well,
only because of inadvertent disclosure in the IT return, an income which is not chargeable to tax cannot become taxable, my lords. Therefore, I have approached this honorable High Court, my lords.
Your Lordship,
Only
for
because of
seeking-
justice-oriented approach, this may kindly be
Lordship,
sent.
for filing appeal before the first appellate, there is no conditional deposit, my lord, like in GST. They have to just file an appeal, and for stay, my lord, he has to approach the assessing authority under 220 subsection 6 to not to treat him as an assessee in default. There, my lord, they can show sufficient reasons, my lord, that it is not chargeable to tax, therefore we are not liable. He will consider that plea, my lord.
Condition is not absolute.
Yes, my lord.
Condition of deposit is
It
not.
is not there, my lord. Only by
It's
way
not
of
absolute.
circular if they seek for stay.
Then we'll make such observation.
My lords, the delay may be kindly condoned, my lords. The CA tables may be directed to decide on merits, my lords. Because this already 6 years, it's highly unlikely
Lordship,
that
I will leave it to your
the CA
lordship.
tables
Regarding
will.
condoning delay, my lord, I will leave it to your lordship.
The
For R1, I will be appearing, my lord. R2 and 3,
Third Counsel Shri Arvind Chavan accepts notice for the respondent 1 and Counsel Sanmati for respondent 2 and 3. The petitioner has called in question the validity of the intimation under 143(1) of the Income Tax Act issued by respondent number full stop. It's the case of the petitioner that the petitioner, being an apartment owners association, receives maintenance charges and other charges from members who are apartment owners. Full stop. It's further submitted that the amount collected towards maintenance is not chargeable to income tax under the principle of mutuality. It is submitted that the amount received being exempt by oversight, no declaration was made under the appropriate column showing the amount as exempt income. Full stop. It is submitted that subsequently the matter has been taken up by the revenue and it has culminated in a notice under 143(1).
Yes, ma'am.
Intimation under
Intimation.
143(1). Full stop. And it's submitted that due to certain bona fide reasons, the petitioner came to know of the demands that were subsequently raised pursuant to the intimation belatedly. It's further submitted that taking note of the amount as being exempt income, This court may set aside the impugned intimations and consequential demands. The counsels appearing for the respondents would submit that the lapse on part of the petitioner to have made appropriate entries in the relevant columns in the returns filed has resulted in the present situation, and it is further submitted as the orders relate orders having been passed in the year 2020, the petitioner may be relegated to avail of the appellate remedy. Full stop. Insofar as the assertion that the maintenance amount collected towards maintenance is exempt income, prima facie, respondents are unable to controvert such assertion. Full stop. However, taking note of the delay, it would be appropriate to remit the matter back to the first appellate authority. Full stop. In light of the explanation made at para 20.
Yes. Yes,
Para,
my lords.
para
20 minutes, starting from para 21.
Yeah. From para 20 onwards, as regards the aspect of delay, it would be appropriate to pass appropriate orders as below. Petitioner is relegated to file an appeal before the first appellate authority as against the orders at annexure A and B. Insofar as the aspect of delay, taking note of the reasons assigned, it would be appropriate to order that if appeal is filed within
30 days.
Within 30 days from date of receipt of certified copy of the order, appeal would be taken up without without raising any objection as regards delay. Such order is passed, taking note that the authorities, statutory authorities, have certain constraints in condoning the delay, while accepting the bona fideness of the explanation for delay as made hereunder. All contentions on merits are kept open. In the event the authorities are to take any coercive steps and the petitioner seeks for stay of the orders, the authority will considering application for stay and deposit to be made to take note of the assertion of the petitioner that the income is exempt in an appropriate manner. All contentions and merits are kept open. Accordingly, the petition is disposed of, reserving liberty as observed above.
Second and the third respondent, I will take notice.
9, Lakshmi Madam.
Hearing for petitioner.
Yes.
Lords, in this particular case, the show cause notice, my lords, was issued because of the difference in the input tax credit I had claimed versus reflecting in the GSTR 2A of 5,78,000 CGST and SGST each, my lords. My lords, the order was passed.
Copy, I'll take note.
My lords,
1 and 2, I'll take notice.
Then Council Arvind Chavan accepts notice for respondent 1 and 2. Yes.
Lords, the order was passed confirming, we had replied to the show cause notice. Subsequently, the order was passed confirming that this is for the period financial year 17-18, my lords. Subsequently, we had received the order. The order was passed dated 6/9/2023, my lords. We had received the order only on 14/10/2023 and filed an appeal on 14/1/2024. My lords, under this scheme of the GST, the appeal to the first appellate authority, we have a time period of 3 months as per 107 of the Act. There is discretionary power for an extra 1 month, my lords, amounting to 4 months. Lords, my submission is that we have filed within the said 4 months, within this condonable period of 1 month, my lords.
Yes.
Lords, he has rejected the appeal without application of mine, passing a summary order.
Lordship may kindly have it next week, my lord. I'll just go through it. If it is so, if they have filed it within condonable period, my lord, then it can be relegated back to the
Counsel,
my lords.
Arvind Chavan accepts notice for the respondents. This is the matter in the preliminary hearing list on Tuesday.
Please be 7.
Tuesday will allow it, let him verify.
10.
Like.
Editor SP, serial number 10.
My lords, there's an ex parte order passed, my lords. What has happened is there was one show cause notice issued for the period 1920, 2021, 2022. Multiple periods, one show cause notice is issued. There was a challenge to that show cause notice, my lord, before this High Court, but there was no stay. When the matter was pending before this High Court, they have passed this order only on the ground that there is a High Court, there is a writ petition filed, but there is no stay, but no hearings were given, my lords. Page number 30, my lords.
Yes, who appears?
State, I will appear.
My lords, why center has been made a party is because, my lords, for the year 1920, center has also issued a show cause notice, my lords, which has been culminated by way of an order as well. So there are multiple parties in this proceeding, my lord. That's why center is, but for this proceeding, my lords, state is the answering authority.
My lord, with regard to state is concerned, we have a JDN. Apart from central, we have a separate JDN. If we initiate inquiry, we can pass an order. That I will get the.
It may be linked with
I'll
the other writ, my lords. We can dispose it of.
No, my lord, because let me read, my lord, maybe taken next week, my lord.
Yes.
Yakandre
Interim stay-
JDN issue ಮತ್ತೆ central multiple
Find
issue
out.
ಇದೆ. I gone through, but still I need instruction.
The AG accepts notice for respondent 224, is it, or 5?
No, my lords. My lords, 2 to 4, my lords.
224. Then counsel G1 accepts notice for 1 and 5.
My lord,
4 and 5.
My
Huh?
lord,
4
respond
and
number
5.
2, 3
4.
and 4, I will take notice, my lord.
4 and 5 is center, my lords.
1 and 5 is center.
1, 4 and 5.
1 and 5.
1 and 5.
G1 accepts notice for respondent 1 and 5. This is the matter.
My lords, interim stay, my lords, because there is a.
Next
Not
week.
required. Next week I will
Please.
submit it. If remand back is there, I will not
This
object.
is the matter in preliminary hearing list on Tuesday.
11. Pradyumna.
Yes, who appears?
The petitioner was granted a refund of
Respondent.
state.
I will take notice, my lord.
CGP accepts notice for the
2022 he was granted a refund, your lordship. In 2025 proceedings were initiated on the ground that part of the refund claim was inadmissible. Actually, the procedure laid under statute is that wherever refund claims are filed, an appeal has to be filed as per section 107 subsection 2 before the Commission of Appeals, and it is clarified by the board also, lordship. Only when the case of intentional evasion, fraudulent, etc., then it has to be proceedings can be initiated section 74. In the present case, proceedings have been initiated section 73, not 74. That means it is a case where all documents were given. The proper course of action should have been to challenge this order by filing an appeal rather than initiating after 3 years. That is also judicial proceedings are also beyond the statutory period.
You take your stand.
I'll take notice, my lord, maybe after 4 weeks, my lord.
Yes, the petitioner has challenged the proceedings initiated by the respondent and has sought for setting aside of the adjudication order at annexure A. In the case of the petitioner, that refund having been granted, same is sought to be reversed by way of present proceedings which are even otherwise belated. Full stop. Further submitted that resort to section 73 ought not to have been made, while the revenue ought to have filed an appeal under 107 insofar as the order of refund is concerned. In light of the contentions raised, there would be stay of annexure A and consequential proceedings. State to the respondents to complete their pleadings within 4 weeks.
One, Rayaraj DS.
With the Lordship's permission, I appear for the petitioner. Seizure of vehicles.
Motor vehicles.
Annexure D, page 63, similar identical matter. Subsidized.
For the respondents is submitted. Actually, the namdu on the very little. Petitioner submits that in an identical factual matrix raising the same legal question, the coordinate bench has passed interim orders, including in WP 35955 of 2025.
Allowed for R1 is concerned.
In light of the same, there would be an interim order, and the respondents are directed not to seize the petition schedule vehicles, while they are entitled to inspect the petition scheduled vehicles and continue with investigation and inquiry. Relist on 2nd of February. Learned HCGP accepts notice for respondents 2 to 5, and Council B promotes for the first response. So and so, Learned Council Nagaraja HR appears for the first response.
May I request for hand delivery, my lord? 7 buses are seized. I'm not able to operate.
Yes, it will be uploaded today itself.
All right. Grateful.
I appear for the petitioner. Ex parte assessment order has been made. Deny the input tax credit under section 16(2), my lord. Similar request is admitted subject to payment of 10% of the tax amount. What of?
ಅಲ್ಲ ಇದು ಆಕ್ಚುಲಿ ಎಕ್ಸ್ ಪಾರ್ಟಿ ಆರ್ಡರ್ ಆಗಿರೋದ್ರಿಂದ let them go and take the contention, my lord, instead of on 226
yes,
challenging the
notification. Matter may be remanded all.
It's let them, they have not taken any contention before the assessing officer.
No.
They have not appeared.
Even without application
locus
of
standi to question the notification.
No, your lordship kindly.
Not fair, my lord, on the part of the petitioner.
So shall we
lordship ink page number 20.
Send it back, my lord, because demand is 34 lakh, my lord.
Lordship kindly ink page number 25, my lord.
24 order 2 ವರ್ಷ ಆಗೋಯ್ತು.
Without application, without ink page number 25, my lord. Well, in one CS, my lord, yes, service of notice has been and he has filed reply, my lord. Now in the last paragraph, my lord, he has not filed any reply, my lord.
ಇಲ್ಲ page number 27 ಅಲ್ಲಿ
opportunity is given. Taxpayer has filed the objection for SCN. Paragraph 4, my lord. Ink page number 25. The taxpayer has filed the objections for a SCN notice filed. In the last paragraph, page number 28, my lord. In spite of opportunities given, taxpayer has failed to reply to the above observation, hence taxability and so on. Without objection, my lord.
So you had not filed reply?
No. Proper notice service is not at all served, my lord. Therefore.
ಇಲ್ಲ ಸರ್ಡ್ GST ಪೋರ್ಟಲ್ ಅಲ್ಲಿ ಇಮೇಲ್ ಅಲ್ಲಿ ಡೀಟೇಲ್ ಆಗಿ
ಅವರೇ ಒಂದ್ ಕಡೆ ಹೇಳ್ತಾರೆ ರಿಪ್ಲೈ ಫೈಲ್ ಮಾಡಿದೀನಿ ಅಂತ ವಿತೌಟ್ ಅಪ್ಲಿಕೇಶನ್.
ಅದೇನೋ ಟೈಪೋಗ್ರಾಫಿಕಲ್ ಎರರ್
let them date may kindly be fixed on the day it will appear and pass.
Petitioner has called in question the validity of the order passed under section 73(9) of CGST/KGST Act. copy of which is enclosed at Annexure C. Perusal of the order at Annexure C would indicate that the order has been passed in the absence of any reply to the observations made by the authority. And counsel for the petitioner submits that due to bona fide reasons, reply could not be made out. And HCGP appearing for the revenue submits that notices were served and the lapse in not making out reply to the observations raised was solely attributable to the petitioner. Next. Having perused the order at Annexure C and noticing that the proceedings have culminated in an order in the absence of any reply on behalf of the petitioner, it would be appropriate to afford an opportunity to the petitioner. Accordingly, accepting the bona fideness of the lapse, it would be appropriate to set aside the order at Annexure A, Annexure C, and remit the matter
Second respondent.
back to the second respondent at the stage of post show cause notice. Petitioner to make out reply to the show cause notice and appear before the authority and participate diligently in the proceedings. Full stop. Petitioner to appear before the second respondent on
4th of February.
Needless to state, if the petitioner does not appear and avail of such opportunity, the indulgence granted by the court would stand revoked. All contentions are kept open.
Demand is 34 lakh money. Minor cost to
Yeah.
the legal service authority.
Cost
Let them
of-
get the benefit.
In taking note of the lapse on part of the petitioner to pay a cost of rupees 5,000 to the High Court Legal Services Committee. Yes.
14, Lakshmi Menon.
What's seeking a passover in this matter?
Passover.
15,
Hearing for the petitioner, my lords.
Yes.
Lords, the service tax matter.
Yes.
Central. 15 is.
So service tax matter, my lords.
Tax on base of ITR.
Yes, my lords. Chinmaya Seva Trust, my lords. I will.
Copies are served, my lordship can have it next week.
Learned Counsel Arvind Chavan accepts note for the response 1 and 2.
My lords, my bank account has been attached, the DRC 12. That is my only source, my lords.
Tuesday we'll dispose it of.
Please.
Now what has happened in those matters? We had remanded.
Where matters have been remanded, my lord, as per the lordship's direction, they have constituted the body, my lord. They are looking into it, they are passing orders after giving adequate opportunity.
My
lords, the same.
Chavan accepts notice for the respondent 1 and 2. List the matter in preliminary hearing list on Tuesday.
Please.
16, Ravishankar SV.
My lords, income tax matter. My lords may take to page 51, my lords. In page 51.
Yes, income tax.
Tirumala.
Yes.
My lords may see the assessment year is 1819, middle of the page. The notice is issued on 34/22.
Page
51, my lords.
Page 51.
51, please. Assessment year 1819, notice issued on 34/22. The last line, page para 3, my lords. Notice is issued by, sanctioned by the PCIT Bangalore 3. Notice should have been by the PCCIT, Principal Chief Commissioner. Sanction is patently wrong.
PCCT.
Principal Chief Commissioner of Income Tax. But this is taken by an officer who is of lower rank, beyond 3 years.
Yes.
Sanction is invalid.
Yes.
It requires further verification, my lord.
Yes, let us see. What is the interregnum what you have sought?
My lords, annexures A to A5 I am praying for stay.
Annexure
A to A5.
the petitioner has challenged the order of adjudication and orders imposing penalty and consequential proceedings by raising a jurisdictional defect insofar as it is submitted that the notice under 148 is issued with prior approval of the PCIT, though the prior approval ought to have been of the PCCIT.
Yes, my lord.
Full stop. There is the notice at annexure A2 in light of the contention raised. There is the stay of
Annexures A to A5.
A to A5.
Please.
Respondents are at liberty to seek for modification of the interim order upon filing statement of objections. Learned Counsel Tirumalesh accepts notice for the respondents.
Obliged.
17, immediately.
My lord, for the petitioner, I beg to appear online, my lord. Is a GST matter orders passed by the state authorities and the annexure A1 at page 27, my lord, is an appellate order passed by the first appellate authority, which is an ex parte order. 3 notices have been issued, my lord.
Maybe
And
remanded
now,
at the stage of show cause notice.
What was the delay?
Not delay, my lord. Here, the appellate at the appellate stage, 3 notices have been issued, and these have been issued through email, and I couldn't answer them and appear for the appellate proceeding. And for non-appearance, it has been dismissed. That is my case, my lord, at page 34, the concluding part.
Remanded before the appellate authority.
My prayer is that it can be remanded to the adjudicating authority because it is an ex parte order even at the stage of adjudication.
Because page number 38, my lord, in adjudication order also ex parte. He has not appeared there also. He filed within time. There also he didn't appear. It is his negligence may be taken as bona fide. ಬಟ್ 10% ಕಟ್ಟಿದ್ದಾರೆ ಆದ್ರೂ ಮೈನರ್ ಕಾಸ್ಟ್ ಆಗಿ ವಾಪಸ್ ಕಳಿಸಬೇಕು ಅಂತ ಯಾಕಂದ್ರೆ ಅಪೀಲೇಟ್ ಅಥಾರಿಟಿ ಎಲ್ಲೋ ಅಪಿಯರ್ ಆಗಲಿಲ್ಲ.
Yes. The government advocate is saying in every case I'm saying bona fide, but she's saying it's not bona fide. The petitioner has called in question correctness of the order.
Page number 38, para number 6 specifically described his this one, my lord.
Yes, has called in question the order passed by the appellate authority at annexure A1, whereby the appeal filed by the petitioner was dismissed for non-prosecution and default. The petitioner, it is noticed, had challenged the order of adjudication at annexure B1, isn't it?
Yes, my lord.
B1 before the appellate authority. A perusal of the order at annexure B1 would also indicate that petitioner has not participated in the proceedings before the adjudicating authority, and the order passed is without benefit of any reply by the petitioner. Petitioner submits that the lapse in not participating in the proceedings is bona fide and in the interest of justice, an opportunity may be granted to the petitioner to make out reply to the show cause notice by reopening the proceedings. Land HCGP appearing for the state would submit that it is a matter of record that petitioner has not only not participated before the adjudicating authority, but has also failed to effectively prosecute the appeal, and accordingly the petitioner is solely responsible for the lapses which has resulted in the orders passed. Taking note of the order at annexure A1 as well as noticing that the adjudication order at annexure B1 is an ex parte order, it would be appropriate to directly address the uh, order at annexure B1 itself. Full stop. Noticing that the order at annexure B1 is an ex parte order, accepting the request of the petitioner for an opportunity to participate in the proceedings, it would be appropriate to set aside the order at annexure B1 and remit the matter to the stage of reply to show cause notice. In light of the lapse of the petitioner to pay cost of rupees.
My lord, I have already paid 10%.
Maybe, my lord, but his negligence is there. One
Cost
minimum
of
on
rupees,
that savra kotli.
5,000 to the High Court Legal Services Committee. Full stop.
Date may be fixed, my
Petitioner to
lord.
be present before respondent number
2, my lord.
2, my lord.
Respondent number 2 on
4th of February.
Needless to state, if petitioner does not avail of the opportunity, the benefit extended in the present order would stand revoked. All contentions on merits are kept open. Full stop. Accordingly, the order only B1, isn't it?
My lord, A1 also needs to be quashed, my lord, because that is the appellate order.
That we are ignoring it.
No, my lord, your lordship has to be quashed, my lord.
Consequentially, it will have to be
Consequent
quashed.
relief again after he goes first adjudication order. If he is aggrieved, he has to make a fresh appeal.
The order at annexure
A1, A2.
Correct. Technically, A1 is the order in appeal. Now we are setting aside the 73(9) order itself.
Yes,
Yes,
my
my
lord.
lord.
Yes,
Yes,
my
my
lord.
lord.
Technically, your
Consequentially, that also needs to be quashed, my lord.
No, why? We are not touching A1. If you set aside A1, then the appeal would revive technically. Suppose.
Yes, my lord.
So the accordingly, order at annexure A2, B1 and B2
Yes, ma'am.
are set aside and matters remitted in terms of the observations made above.
Grateful.
SV.
Yes.
18, Ravi Shankar.
Yeah.
18.
What is the number?
List 218. List 218 is
Okay.
List 218, Ravi Shankar.
That's for the petitioner, my lords. This is a GST writ petition challenging the ex parte order passed, my lords. We've challenged on the ground that it's barred by limitation, my lords. Notification, perhaps the respondents have relied upon notification 9 and 56, which is the subject matter before the Honorable Apex Court. On that ground, I'm seeking a stay, my lords. Ultimately, it has to be remanded back, my lords. But in the meanwhile, if I may request, my lords, for a stay of the
My lord, the notification issue is concerned may be pending before the Apex Court, my lord. First of all, this is ex parte order. He has not appeared. He has not taken contention. Let him go and appear before the authority and take all contention may be kept open.
All contents may be kept open, my lords, if it's subject to what my learned friend says.
But,
If it can be remanded back, I'm deeply obliged.
What is
But
the
order is, my lord, 29/8/2024, my lord.
My lords,
For that reason, some minor
my lords,
cost may be
immediately,
awarded, my lord.
my lords, immediately upon knowledge of the order, my lords, I had sought for a rectification also, my lords. The rectification letter is in page number 132, my lords.
No order is passed.
My lords?
No order is passed.
No, my lords. They say that we cannot rectify it. And the moment I realized, I have voluntarily made payments also, my lords. Voluntary payments are in page number 136, my lords. 36, madam. 136. Or it can be seen in page number 9 of my synopsis also. I've provided the list of dates when I have voluntarily made certain payments. Page number 9, madam. Due to my ill health, I couldn't participate, my lords. In response to audit also, I filed
But we have
documents.
served on the portal, my lord. I have instruction, we have served. They will take all petitioner advocates, no service, but we have served on portal.
It's under the
And email
additional
specifically. And
notice.
one more facility is given, they will give phone number, SMS alert also we have sent.
Where have you stated ill health?
My lords, it's in my rectification request, my lords. My lords, page number 132, my lords.
The petitioner has called in question the correctness the order in original passed under section 73(9) at annexure E1. Petitioners also sought for setting aside of the summary of the order in original at annexure E2. Full stop. Other reliefs are also sought. Full stop. It would be appropriate to notice that the order at annexure E1.
My lord, sorry for interrupting, apologies, my lord. Rectification is filed after condonable delay of the first appellate. That's why they have not considered, my lord.
It is noticed on the perusal of the order of adjudication that the order of adjudication is passed in the absence of any reply to the show cause notice by the taxpayer. So it's a best judgment assessment.
Best judgment, yes, my lords.
The assessment order is passed on the basis of a best judgment assessment. Full stop. It is the case of the petitioner that in light of ill health of the petitioner, no reply could be made out to the show cause notice, which has resulted in an ex parte order passed, and submits that court may remit the matter back to the stage of reply to show cause notice and afford an opportunity to the petitioner to participate in the proceedings. Then HCGP would submit that petitioner is solely responsible for the lapse on his part, resulting in ex parte orders passed. Next, taking note of the order at annexure A1 being an order passed in the absence of any reply on merits by the petitioner, to meet the ends of justice by remitting the matter back to the adjudicating authority, accepting the bona fideness of the lapse. Full stop. Note is taken of the assertion by the petitioner that due to ill health, petitioner was not able to make out reply to the show cause notice. Full stop. Accordingly, in order to afford an opportunity to the petitioner, the order act annexure A1 is set aside and matter is remitted to the stage of reply to show cause notice. Now, what are the other orders that have to be set aside?
Only the A1 and A2, my lords. Apart from that, I've challenged the show cause notice, that may be kept
The
open.
order of at annexure A2 is also set aside. Matter is remitted to the stage of post show cause notice. Petitioner to make out a reply to the show cause notice. All contentions and merits are kept open. Accordingly, petition is disposed of in terms of the above. Petitioner to appear before the authority on. Needless to state, if the petitioner does not avail of the opportunity provided by this court by appearing before the authority, the indulgence granted by this court would stand revoked.
Lords, may I make a submission? All contentions may be kept
All
open,
contentions
including
and
my limitation.
merits, all contentions and merits are kept open.
My lord, cost may be, my lord. 83 lakh is there.
Petitioner to pay.
My lords, I've challenged the extension period of time, my lords. It's pending before Supreme Court.
Let it be, my lord. We are not.
Because they have relied.
Delay is there, my lord. Extensive delay 226 ಅಲ್ಲಿ ಬರ್ಬೇಕಾದ್ರೂ ಡಿಲೇಗೆ ಒಂದು ಮಿನಿಮಮ್ ಒಂದು ಕಾಸ್ಟ್ ಕೊಟ್ಟಿದ್ರೆ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿಗೆ ಹೆಲ್ಪ್ ಆಗುತ್ತೆ ಇವರಿಂದಾಗಿ.
Corporate social responsibility. Cost of rupees 10,000.
My lords, 5,000 if I may request, my lords. It's all expert. I'm a work contract, my lords. Humble request, my lords.
Cost of rupees 5,000.
Obliged, my lords.
Don't pay it from your fees. Yes.
My lords, ultimately, that is
to the High Court Legal Services Committee. Yes.
19.
Obliged, my lords.
You have to pay court fee. Court fee.
Complied with court fee.
You paid. Yes.
Demand of state road tax during the subsistence of a valid national permit. Connected matters.
Same order.
Serial number 5.
Yeah, where is it? The same order as in
serial number 5. That's 512.
Last order. Motor vehicles tax. 12. Same orders in 12. HCGP accepts notice for the respondent. Motor vehicles tax, madam.
Tax. Motor vehicle tax.
Motor vehicles tax.
Second.
Same matter.
They have not served the copy. Kindly.
List on same order. List on 2nd of February.
Much.
Subsection second time, serial number 20.
There one sentence barkode. The petitioner just one. The only office objection raised was regarding non-payment of court fee. Petitioner files a memo and submits that court fee is paid. Yes.
That's for the petitioner. That's 2 weeks time may be granted to comply of
2 weeks time granted for necessary compliance.
21. Sangamesh RB.
21 lords, I beg to appear for the. This is that matter, lords, where I have sought for extension of the termination term of the arbitrator, lords,
mandate
under the National Highways Act. So there are 4 matters were disposed. So far as one office objection regarding DCF, lords, it is only one case I have sought for extension of time, lords. Maybe the claimants are many. The office has raised multiple court fees to be paid.
And so far as office objection at serial number 1, it's submitted though the number of petitioners are multiple. However, relief sought for is only with respect to one proceeding. Accordingly, office objection at serial number 1 is overruled. Others?
Lords, there's one, the other one is, lords, I'll comply. Lords, 6th one, the death certificate, lords, I'm furnishing it now. Lords.
The petitioner has filed death certificate of appellant 225. Appellant.
Others may be overruled, lords.
Is it appellant?
It is the petitioner, lords.
Petitioner.
3 deputy. Ali cost title Ali Krishnappa Lords Nandagopal. We have just named them, but then we have not those death certificates we are producing. LRs are already there.
Petitioners produce the death certificate of petitioner number 2 to 5 before the arbitrator, isn't it?
2 and 5 Lords.
2 and 5 before the arbitrator. In light of the same, and taking note of the submission that the legal representatives of the
Are already on record.
said petitioners are already on record. Office objection seal number 6 is overruled. Other office objections, you have served copy.
I've served the copy.
Office objection seal number 4 is overruled, noticing that copy has been served. Other office objections, it is submitted, would be complied with in the course of the day.
Lords, 3 Lords, they say department has to be. I have mentioned national highways. Lords. The other petitions also have similarly mentioned.
Respondent 3, my lord, state will accept the notice, my lord.
Office objection seal number 3 is overruled. Five.
Lords, 5 annexure B to be stated at prayer notes. That also can be overruled. I'll do it, Lords, that small correction.
Petitioner submits that office objection seal number 2 and 5 would be complied with during the course of the day. AGA accepts notice for respondent number
3, man.
3.
3, man.
Learned Counsel N. Kumar for 1 and 2.
1 and 2.
1 and 2. Same order. Learned Counsel N. Kumar is permitted to file wakalat. Same order.
Lords, may I furnish the earlier order number?
Yes.
One request, Lords.
Yes.
The Lordships in the earlier orders was directed me to file within 1 week. The copies, I have of course filed it, Lords. The copies can be released, Lords.
Check on it.
I'm okay.
22.
I didn't check.
AIDB acquisitions, definitely. There is a gap of more than 14 years, Murad, in between the preliminary and final notification. The Lordship said, Murad, the other day, unless Chandrasekhar comes up, the Lordship said order will be granted only when he comes. Murad. Now he is here. Interim order, Murad, I have sought for. Let him take time for objections, let him file. But Murad, they are on the spot, Murad, they are troubling me, Murad. I have made investments here. 14 years, Murad, delay between the. October 2024.
Mike.
2010 was the preliminary notification.
After
2024 is the final. 14 years, Murad, gap between the preliminary and the final. Number of matters your Lordships already entertained, granted the interim order. We are in possession of the property, produced documents, Murad. Record of rights are there. Let him file objections. I don't mind.
I have to file objections. That the final notification 3rd October 2024. After 1 year, they approach the Sound Court for grant of interim order.
Correct. They're saying between 10 to 14, 10 to 24.
Yes.
Yes. 14 years. Actually, matter squarely covers, Murad. Identical matter. 14 years. Your report.
Petitioners have challenged the validity of the proceedings of acquisition insofar as there has been a delay of about 14 years between notification under section 28(1) and declaration under section 28(4). In light of the assertion made, it would be appropriate to consider the request for interim prayer, and accordingly there would be stay of
Annexure G, Annexure G.
Stay of annexure. There would be an interim order of a stay of dispossession of, no, but then they'll go ahead with the award, etc.
Problem Annexure G, your Lordship has stayed in other matters. Annexure G stay madi. Let him file objections, Murad, thereafter main matter.
The interim order of stay of annexure G insofar as the petitioners are
concerned.
Respondents are at liberty to seek for modification of the interim order upon filing their statement of objections.
Hand delivery, may I see? They have sent other notices. my lord. Great.
Huh? Huh.
3 objections. Serial number 1, Mohammed.
So it's a covered matter, my lord. Maybe taken up 230, my lord.
No, you take out notice to the BDA.
I'll serve the copy, my lord. It's a short matter. Mandamus.
No, correct. No, somebody must be there.
I'll serve the copy, my lord.
So we'll have it on the next day. Serve copy. I'll have it in the preliminary hearing list and we'll allow it.
Please, my
BDA.
lord. I've spoken to him. He's in court hall number 1. He said that he'll come by 2:30, my lord.
Who? Who?
Krishna, my lord.
Huh?
Krishna.
That we'll see. Yeah. Land Counsel K. Krishna is directed to accept notice for the respondent. List the matter in the preliminary hearing list on
Tomorrow, my lord.
office objection
Course of the day, I'll do it.
to be complied with.
Tomorrow, my lord.
A previous matter. It will come on the land acquisition day, whichever date court officer gives.
Respondent number 1 mala state.
AG accepts notice for the first respondent.
Respondent.
ಆ ಹಿಂದಿನ ಮ್ಯಾಟರಲ್ಲಿ ಅದು ಒಂದು ಇಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಟ್ಟರು ಅದರ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಟು ಬಿ ಕಂಪ್ಲೈಡ್ ವಿತ್ ಫೋರ್ತ್ ವಿತ್ ಅಂತ
I'll do it in the course of the day, my lord.
Yes, yes.
Unless a date may be fixed, otherwise it's
We
very
fixed a
difficult.
date. We fixed a date.
Acha, bhai. Sir.
Next one, non-compliance matters. Serial number 1, Pradyumna.
Akash Shetty has stopped here for respondent. It's another court lordship. There is one office objection which may go.
No, otherwise I'll pass it over, let him come. Pass over.
Serial number 2, Sridhari.
Please, my lords. My lords, this is a GST writ petition.
Yes, who appears?
My lord, I appear, my lord. In this case, my lord, I am preparing the statement of objection. Today I have received parawise remarks, my lord. This may be taken.
Lordship may kindly grant me an interim order, my lords.
It is covered by decision. Gujarat High Court judgment is
Interim
in
order.
our favor, my lord.
Interim order earlier granted is extended.
But there is no interim order in this case.
No interim order, my lord. Not
I'm praying
required,
for it.
even not required, my lord.
I'm praying for interim order.
No, my lord. Interim order cannot be granted, my lord.
ಅಲ್ಲಲ್ಲ ಇದು ಯಾವುದು 37324
ಇಲ್ಲ ತಾನೆ?
ತೋರ್ಸ
Interim order cannot be. ಏನೋ ಮಾಡಿದೀರಾ last time.
Please. I'm obliged. I'm very obliged.
I opposed, but I don't know.
anyhow it's not me.
Last minute ಅಲ್ಲಿ ಇವರು last minute ಅಲ್ಲಿ ಈ ತರ
Lordship may
order
kindly grant a
ಬಂದಿದೆ.
short date because there is a attachment made in this case, hence the urgency, my lords. My properties have been attached wrongly by the respondent number 1 who does not have the jurisdiction.
When will you complete it?
My lord, next week, my lord. Today I will do it, my lord.
Really?
I have received, I will do it, statement of objection.
Interim order earlier granted is extended till the next date. Relist the matter on 3rd of February.
Obliged.
Yesterday.
Just see what that office objections are.
Please.
Office objection.
I will do it.
No comment.
My lords, I appear for the.
Just wait, just wait.
We'll comply, my lords.
As it is.
My lord, in this case, my lord, sorry, my lord, they have a two cases, my lord. In this case, matter may be, they have to avail the appeal remedy, my lord. Two order is passed separate. I will file statement of objection.
You file it, let us. File it, let us.
Two orders separate, independent issue is, they are taking it is a parallel proceedings. It is not so parallel proceedings.
The matter is.
No, let us see, you file.
I will file, ma'am.
Supreme Court in the case of armor security, my lords, lays down the law on this point.
The office objection is overruled as AGA submits that copy has been served. What is the point?
The point in this case, my lords, there are two procedural administrations always, state and central. The Supreme Court has said that both state and central can concurrently assume jurisdiction on the issues of tax evasion. But among the state administration, two different authorities cannot assume jurisdiction. There can be only one proper officer under the state administration, which is the point clarified by the Supreme Court in the armor securities. In this case, my lords, for the very same financial year 21-22, two different authorities have assumed jurisdiction.
For different issues, my lord. They can, that can be
issue.
done,
The Supreme Court has defined what the subject matter means. Subject matter is the issue that is proposed in the show cause notice. The issues proposed by the first authority who assumed jurisdiction in this matter in the show cause notice is the non-availment of ITC properly. Now that is the subject matter. On the very same issue of ITC, second authority cannot assume jurisdiction and issue a separate show cause notice highlighting different variants of it. Once an authority assumes jurisdiction on the issue of ITC, he shall get exclusive jurisdiction.
But all these are mixed questions of fact.
No, on the question of, I'm only on the issue of law, my lords.
Correct, but you have to interpret whether there is an overlap or not.
Because this issue cannot be decided by the lower authorities in the appeal jurisdiction. This is a purely a question of law.
We'll see. Yes.
Please.
3, Arun BM.
Lords, I appear for the petitioner. This is acquisition for suburban railway, my lords, laying of a high transmission line by KPTCL. My lords, on 26/12, there is an interim order passed by this honorable court. My lords, in the interim order, my lords may kindly see paragraph number 6, my lords.
Well, already joint inspection has been done. Still, it has not been concluded. Some more time is required to feasibility of the laying the lines.
The KPTCL is the fifth respondent, is the proper authority which should take the initiative for joint inspection and joint meeting. In the order, only the petitioner and respondent number 4 name is there. My lords may clarify that the fifth respondent should take the initiative, because high tension transmission line, it is the fifth respondent which has jurisdiction, though acquisition is by KADB for fourth respondent, K-Ride.
It's already, VL Sanjeev name has been shown, my lord.
Advocate appeared here, but the initiative for joint inspection should be by fifth respondent.
Yes. I am a beneficiary. Joint inspection along with the party as well, the KPTCL, it has to be.
What I am suggesting alternative is for the.
Lords, I appear for respondent 2 and 3, my lords.
Copies have been served.
Yes, I have served the copies on everybody, my lords. KADB also.
There is some office objection.
My lords, one is non-service of copies on KADB that I have done. Advocate has appeared, Karthikeyan.
Please.
Office objection at seal number 1 is overruled in light of the submission that copies have been served. Second office objection.
In the prayer, instead of first respondent, it is mentioned third respondent. I'll carry out tomorrow, my lords.
Petitioner undertakes to comply with the office objection by correcting the number of the respondent in the prayer column. In light of the request made, petitioners permitted to correct the prayer column.
Please.
Interim order earlier granted is extended till the next date. You find out.
Yes. Please.
Now they're saying that you are the authority to do the joint inspection.
They will give approval.
You find out.
My lords,
Previous time.
Relist after 2 weeks.
Please.
Without an order, KPTCL is finding it difficult, my lords. Without an order, if we may not.
Clear that the joint inspection contemplated requires the involvement of respondent number 5.
Please, my lord.
Please.
4, Madhu N. Rao.
Lordship, filing a memo.
But you must intimate.
Yes, Your Lordship.
You have to intimate the party.
We have been trying to contact, not able to.
Correct. So you send a registered post and you enclose the postal receipt.
Yes, sir.
I'll adjourn it to another date.
Okay, yes.
Counsel for petitioner submits, memo of retirement would be filed in light of the same. Relist on after 10 days. 17th. Meanwhile, you send the intimation by email if it is there or by post and then enclose it along with that.
5. Harish VS.
Require short time, please. Just 1 week, very next month.
At request, relist, hale matter next week.
27. 6. Tanmay.
Is covered by the Supreme Court's decision. Matter, my lords, is a second round litigation arising out of 148 proceedings for reassessment. Originally, my lords, the reassessment notice under 148 was issued on 29th June 2021. Now, my lords, from 1st April of 2021, the whole scheme of 148 had changed. And earlier, they used to issue a 148 notice, on account of which I had to file a return, ask for the reasons recorded, then the reasons would be furnished. But this was codified, my lords, and 148A was brought into the picture from 1st April 2021. Now, in my case, 29th June 21 was when the notice was issued, but it was not issued under 148A. There was no show cause notice under 148A. A 148 notice was directly issued. The assessee challenged this in a writ petition before this honorable court. Several other assessees also had challenged. All of those writ petitions were allowed. Then the matter traveled up to the Supreme Court. Supreme Court said, yes, all the High Court orders which have quashed these notices are correct. But in exercise of powers under Article 142, the Supreme Court said, we are going to treat all these 148 notices as 148A show cause notices. In Ashish Agrawal, that was the decision of the Supreme Court. They said, we will treat these as show cause notices under 148AB. And time should be given to the assessees to submit replies. Information relied upon has to be furnished and time to be given to the assessees to furnish replies. And thereafter, the proceedings have to culminate in a 148 notice. Now, that order of the Supreme Court, my lords, we'll see at page 58. All other contentions, my lords, was left open. The conclusion, my lords, is at para 10 on page 70. May I read, my lords? Para 10. In view of the above and for the reasons stated above, the present appeals are allowed in part. The impugned common judgments and orders passed by the High Court of Judicature at Allahabad in so and so and other allied tax appeals are hereby modified and substituted as under. The impugned section 148 notices issued to the respective assessees, which were issued under unamended section 148 of the IT Act, which were the subject matter of writ petitions before the various respective high courts, shall be deemed to have been issued under section 148 of the IT Act as substituted by the Finance Act 2021 and construed or treated to be show cause notices in terms of section 148AB. The assessing officer shall, within 30 days from today, provide to the respective assessees information and material relied upon by the revenue so that the assessees can reply to the show cause notices within 2 weeks thereafter. Then, my lords, 2 is not important. They basically say the inquiry under 148A has been dispensed with. Kindly see 3, my lords. The assessing officer shall thereafter pass orders in terms of section 148 AD in respect of each of the concerned assessees. Thereafter, after following the procedure as required under section 148A, may issue notice under section 148 as substituted. All defenses which may be available to the assessees, including those available under section 149 of the IT Act, and all rights and contentions which may be available to the concerned assessees and revenue under the Finance Act 2021 in law shall continue to be available. Now, my lords, pursuant to this, the information to me was given at Annexure H, my lords, page 77 on 19/5/2022. I've also prepared a chart, my lords, of the important dates. The Supreme Court's judgment, my lords, was on 4th May 22. They said within 6 weeks from today, you have to give the information. That was rightly done, my lords, at Annexure H. 19/5/22, the information was given to me. The date by which I was supposed to file the reply, my lords, was intimated as 3/6/22. My lords will get that at page 78. And I filed my response on that day. 3/6/22 is my response at page 79. Now, my lords, the 148A(d) order and the 148 notice, my lords will see at page 99 is 37/2022. Page 99, my lords will see the 148 notice. It's dated 37/2022. Now, all these second round notices, my lords, again travel to the Supreme Court. And Supreme Court in Rajiv Bansal's case said that as per your original notice, which was issued between 1st March 2021, 1st April 2021 and 30th June 2021, you said that the limitation is expiring on 30th June 2021. So in a given assessee's case, you see the surviving period of limitation from the original notice. In my case, it is 29th June 21. So the surviving period of limitation was 1 day that was left for the revenue. So the Supreme Court said, after excluding all this period between Ashish Agarwal and issuance of the information, which is at page, which is 19th May 22, my lord saw that, the revenue has to issue the 148 notice within the surviving period, which is, in other words, 1 day. So my lord saw that they gave me time till 3rd June 2022 to file the reply. So ideally, they should have issued the 148 AD order and 148 notice on 4th June 22. But there is a proviso that says that where the number of days after the filing of reply is less than 7 days, the limitation will stand extended by 7 days. Therefore, my lords, they had time up to 10th June 22 to pass the order and issue the notice. My lords will just see.
Yes, what do you say? So you should have passed it before 7th of July.
Before 10th of June, my lords. Before 10th of June 2022. If my lords will see the list of dates I just handed over, my lords.
Just point out that.
The proviso, my lords, the extension of time.
Yes. Good.
My lords will just take 149. My lords may kindly take the 2022 Act, my lords.
Now that has also changed, isn't it?
The provisions have slightly changed. Therefore, my lords will have to read the footnotes if my lords are referring to this year's Act. This is easier, my lords, to read. My lords will get page 149.
Now this 148A, etc. is done away with.
148 is there, just that the procedure has undergone a change.
A, B, AD is done away with.
It is renumbered.
Huh? Same procedure. So that AD procedure still stays.
The procedure stays, it's renumbered as 1, 2. And some small other changes in time limits now. My lords will see page 1.1003, section 149. The time limit to issue the notice. (149) Yes. No notice under 148 shall be issued for the relevant assessment year if 3 years have elapsed from the end of the relevant assessment year, unless the case falls under clause B. Admittedly, I am falling under clause A according to them. Now kindly see, my lords, the third proviso there, provided also that for the purposes of computing the period of limitation, my lords has that, Provided also that for the purposes of computing the period of limitation as per this section, the time or extended time allowed to the SSE as per the show cause notice issued under clause B of section 148A, or the period during which the proceeding under section 148A is stayed by an order or injunction of any court shall be excluded. Provided also that where immediately after the exclusion of the period referred to in the immediately preceding proviso, the period of limitation available to the assessing officer for passing an order under clause D of section 148A is less than 7 days, such remaining period shall be extended to 7 days, and the period of limitation under this subsection shall be deemed to be extended accordingly.
That is the only relaxation.
That is the relaxation.
That is the only relaxation.
That is the only relaxation. Now, if my lords will see the list of dates that I passed on. So assessment year, my lords, is 1617. The original notice was issued on 29/6/2021. The number of days of surviving time available till 30/6/21 was 1 day. Now, date of providing the information pursuant to Ashish Agarwal Supreme Court decision was 19/5/22. Due date for filing the reply was 3/6/22. I filed my reply on 3/6/22. The actual date on which the 148 notice was issued on 30/7/22, but actually the last date for issuing the notice was 10/6/22, my lords, giving the benefit of the extended 7 days. Because if I filed my reply on 3/6, he ought to have issued the notice by 4/6. But I am giving a benefit of 7 days because of the proviso. So that is 10/6.
This is after taking note of the time it was stayed.
Yes, my lords, yes. The complete period during which my note from 29/6/21 till 3/6/22, I've excluded the time.
3/6/22 is out of the apex code.
No. I've excluded time till my response to the show cause notice pursuant to the Supreme Court decision. And in fact, my lords, this honorable court has also already allowed these kind of petitions. I'm just passing that also, my lords, for your kind consideration.
So this 3-year got extended because of the stay.
Yes, my lords. Because of the Supreme Court's decision in Ashish Agarwal, it has been construed as a stay. That is what in Rajiv Bansal the Supreme Court says. Supreme Court says you exclude the entire time from 2021 first notice up until Ashish Agarwal decision and the time given to them to give me the information and the response there. So the entire period is excluded.
Which para?
My lords, in that Airbus decision, Rajiv Bansal of Supreme Court has been relied upon. The entire decision virtually, my lords will have to do. It extracts Rajiv Bansal, but para 6 onwards is the discussion. Para 6 at page 6, my lords.
Yes.
As rightly contended by the learned counsel for the petitioner, in the light of the undisputed fact that the respondent provided information to the petitioner pursuant to the judgment of the apex court in Ashish Agarwal's case on 18/5/22, in my case it was given on 19/5/22, to which the petitioner submitted a reply on 27/5/22, the period of limitation for passing the impugned order under 148 AD and also issue notice under 148, which expired on 9/6/22, and consequently the impugned order and notice dated 29/7/22 is hopelessly and clearly barred by limitation as held in Rajiv Bansal's case as supra as hereunder. Paragraphs of Rajiv Bansal have been extracted. Then, my lords, the court also relies on a Gujarat High Court decision where relying on Rajiv Bansal notice was quashed. Then, my lords, para 8 on page 13 is the final conclusion. Similar view has been taken by a High Court of Delhi and other High Courts. Under these circumstances, I am of the considered opinion that the impugned order and notices at annexures L and M deserve to be quashed.
The petitioner has assailed the instruction bearing number 1 of 22 dated 11/5/22, comma, order at annexure K dated 30th July 22, passed by the first respondent under section 148 AD of the Act, as well as petitioner has challenged the notice dated 30th July 22, passed under section 148 of the Income Tax Act for the assessment year 2016-17. The petitioner submits that now the limitation is insofar the 148 or 148 AD.
148 and AD, my lords.
Huh?
Both go hand in hand. Prior to the issuance of a 148 notice, 148 AD order has to be passed. But practically in every case, my lords will see that 148 AD order is issued on one day and immediately a 148 notice is issued.
The petitioner, the facts made out are that the assessing officer had passed an assessment order under section 143(3) of the Income Tax Act for the assessment year 2016-17. Next, the first respondent issued a notice under section 148 under the unamended provision as it was in prevalence on 29/6/21. The petitioner had furnished a copy of return by way of reply, and subsequently notice under 143(2) read with 147 was issued